Hello everyone. In line with PS 211, Politics and Governance with Philippine Constitution, I was assigned to discuss the Article 6 of the 1987 Philippine Constitution, which is the Legislative Department. And without further ado, I will now discuss the sections of this article from section 1 to section 32. Section 1. The legislative powers shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provision on initiative and referendum. When we say legislative power, it is the authority under the Constitution to make laws and subsequently, when the need arises, to alter and repeal them. And when we say law, it refers to statutes, which are the written enactments of the legislature governing the relations of the people among themselves or between them and the government and its agencies. And there are 5 functions of law. First is it defines the rights and duties of the citizens. Second, imposes tax. Third is appropriate funds. Fourth is it defines crimes and provides their punishment. And lastly, creates and abolishes government offices. So the legislative power is vested to 2 legislative branches, which is the House of Senate and the House of Representatives. And the House of Senate is composes of the senators, and the House of Representatives composes of different congressmen. The 2 Congress of the Philippines is a bicameral body composed of Senate and House of Representatives. The first being considered as the upper house and the second the lower house. And the primary function of Congress is to legislate. So there are 2 classifications of power of Congress. First is the general legislative power. It is the power to enact laws intended as rules of conduct govern the relationship among individuals and the state. Second is the specific powers, which consist of first, choose who will be the president in case of temporary disabilities or death of the incumbent president. Second, confirms appointment made by the President through the Congress Commission on Appointments. Third is promote social justice. Fourth is imposes tax. Fifth, impeach a high position government official. And lastly, act as Constituent Assembly in case of any changes being made in the Constitution. Third is we have this implied power, or the power needed to enact a law. The inherent power, which consists of the eminent domain, acquiring any private property to be used for the use of public. Second is the power of taxation, creating laws regarding taxation. And the police power, enacting law through the help of the police force. So also, there is this principle of checks and balances implied on the legislative department. First is the legislative department is being checked by the executive branch through checking the laws made by the Congress. Any bill without the signature of the President is void. The President can disapprove the bill being submitted. Second, the President's veto or the disapproval of a bill can be removed by a voting of the House of Representatives. There must be at least 2/3 vote of the total representative must be gathered to override the veto. And lastly, laws created by the Congress are also being confirmed by the judiciary by checking it if it does not violate the Constitution. Section 2. The Senate shall be composed of 24 senators who shall be elected at large by the qualified voters of the Philippines as may be provided by law. In this section, it discusses the composition of the Senate. There are 24 senators. They have 6 years term. The Senate is alternately being elected, meaning every election, only 12 senator seats are vacant, while the remaining 12 is still in the position. They are elected by qualified voters of the Philippines and is duly registered at Commission on Elections. Section 3. No person shall be a senator unless he is a natural-born citizen of the Philippines and on the day of the election is at least 35 years of age, able to read and write, a registered voter, and a resident of the Philippines for not less than 2 years immediately preceding the day of the election. When we say registered voter, we will define what is a registered voter. It is the one who has all the qualification for a voter and none of the disqualifications provided by law, and who has registered himself in the list voters. And residence is the place where one has true permanent home and to which, whenever absent, he has the intention of returning. And I think Section 3 is very self-explanatory. As long as the person is 35 years old and able to read and write, a registered voter, he or she can be a senator. And it is worthy to note that the age is fixed at 35 and must be possessed on the day of the election. That is when the polls are opened and the votes cast, and not on the day of the proclamation of the winners by the Board of Canvassers. With regard to the residence requirement, it was ruled in the case of Lim versus Pilaes that it must be the place where one habitually resides and to which he, after absence, has the intention of returning. And the enumeration laid down by the Constitution is the exclusive under this Latin principle, expressio unius est exclusio alterius. And this means that the Congress cannot anymore add additional qualifications other than those provided by the Constitution. And a senator must be a natural-born citizen. We refer to the Article 4, Section 2, able to read and write, thus that even an ordinary people can run as long as they have the political will to serve, and a registered voter of the Philippines and a resident here. Section 4. The term of office of the senators shall be 6 years and shall commence, unless otherwise provided by law, at noon on the 30th day of June, next following the election. No senator shall serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. The elected senators are only given 6-year term of office. Again, 6 years term of office. After which, they should leave their office on the noon of 30th day of June, following their election on the month of May. Therefore, in the year 2022, the outgoing senators are Senator Laila de Lima, Senator Franklin Frank Drilon, Senator Sherwin Win Gatchalian, Senator Rich Dick Gordon, Senator Ana Ferecia or Risa Hontiveros, Senator Panfilo Ping Lacson, Senator Emmanuel Manny D. Pacquiao, Senator Francis Pancratius, Kiko and Pangilinan, Senator Ralph Recto, Senator Vincent Tito Soto III, Senator Emmanuel Joel Villanueva, and Senator Juan Miguel Migs Subiri. And no senator shall serve for more than 2 consecutive terms. If a senator has served his term but voluntarily renounced it, then automatically it will add up to his 2 consecutive term without regards for its office tenure. The purpose of continuity of the life of the Senate is intended to encourage the maintenance of Senate policies as well as guarantee that there will be experienced members who can help and train newcomers in the discharge of their duties. Section 5. Number 1. The House of Representatives shall be composed of not more than 250 members unless otherwise fixed by law, who shall be elected from legislative districts apportioned among the provinces, cities, and the metropolitan Manila area in accordance with the number of the respective inhabitants, and on the basis of a uniform and progressive ratio, and those who, as provided by law, shall be elected through a party-list system of registered national, regional, and sectoral parties. Second, number 2, the party-list representatives shall constitute 20% of the total number of representatives, including those under the party list. For 3 consecutive items after the ratification of this Constitution, 1/2 of the seats allocated to party list representatives shall be filled as provided by law by selection or election from the labor, peasant, urban poor, indigenous cultural communities, women, youth, and such other sectors as may be provided by law except the religious sector. Excuse me. Each legislative district shall comprise, as far as practicable, contiguous, compact, and adjacent territory, each city with a population of at least 250,000, or each province shall have at least 1 representative. And fourth, within the 3 years following the return of every census, the Congress shall make a reapportionment of the legislative district based on the standards provided in this section. So, in this section of the Article 3 in this section of the Article 6 of the Constitution, it states that there are 250 representatives or congressmen that composes the House of Representatives. And the House of Representatives composes of different provincial, city representative, and different party lists. According to the Constitution, they are only given 3 years term of office. And the members of the House of Representatives are elected by the registered voters of the Philippines during the election. A province or city with at least 250 constituents shall have 1 representative which represents the people to the Congress. Section 6. No person shall be a member of the House of Representatives unless he is a natural-born citizen of the Philippines on the day of election and is at least 25 years of age, able to read and write and accept party list representative, a registered voter in the district in which he shall be elected, and a resident thereof for a period of not less than 1 year immediately preceding the day of election. Section 6 is very self-explanatory. The qualification of the members of the House of Representatives, a natural-born citizen of the Philippines on the day of election, is 25 years old, able to read and write, a registered voter, and a resident for not less than 1 year in the district where he will be elected. Very, very self-explanatory. Section 7. The members of the House of Representatives shall be elected for a term of 3 years. which shall begin unless otherwise provided by law at noon on the 30th day of June next following their election. No member of the House of Representatives shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. So again, we have to define term versus tenure. Term refers to the period which an official is entitled to hold office, while tenure refers to the period during the official actually holds the office. So the term of the office of the representative shall be 3 years, and the term of office of representative shall commence on 12 noon of June 30 next following their election, otherwise or unless provided by law. A representative may not serve more than 3 consecutive terms, so they are only given 3 consecutive terms. However, he may serve for more than 3 terms, provided that the terms are not consecutive. So why 3 years? One purpose in reducing the term for 3 years is to synchronize elections, which in the case of the Senate are held 3 years interval to elect one half of the body, and in the case of the President and Vice President every 6 years. So voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. Then, Section 8. Unless otherwise provided by law, the regular election of senators and the members of House of Representatives shall be held on the second Monday of May. So, next year, in the year 2022, there will be an election on the second Monday of May. And I am encouraging you to register and vote for the right person in the position who has political will, who can help the people. And again, the regular election of the senators and the House of Representatives will be held on the second Monday of May. And we have these 2 kinds of election for members of Congress. First is the regular election, which is held on the second day of Monday, and the second is a special election, may be called in case of vacancy arises in the Senate or House of Representatives to fill in such vacancy in the manner prescribed by law. Section 9. In case of vacancy in the Senate or House of Representatives, a special election may be called to fill such vacancy in the manner prescribed by law. But the senator or member of the House of Representatives thus elected shall serve only for the unexpired term. If there is vacancy in the Senate or in the House of Representatives, the newly elected one shall serve the unexpired term. So the Constitution mandates that there should always be adequate representation for every province or legislative district. If a vacancy occurs in a manner contemplated in the Constitution, the Congress has the authority, if not the duty, to call for the special election, just in the case of Losada versus Comelec of 1983. So a special election to fill in a vacancy is not mandatory. In a special election to fill a vacancy, the rule is that a statute that expressly provides that an election to fill in a vacancy shall be held at the next general elections, fixes the date at which the special elections is to be held and operates as the call for that election. Consequently, an election held at the time thus prescribed is not invalidated by the fact that the body charged by law with the duty of calling the election failed to do so. This is because the right and duty to hold an election emanate from the statute and not from any call for election by some authority. and the laws thus charges voters with knowledge of time and place of election. And special election can be found in Republic Act 6645. Special election. No special election will be called if vacancy occurs at least 18 months before the next regular election for the members of the Senate. At least 1 year before the next regular election members of Congress. Number 2. The particular House of Congress where vacancy occurs must pass either a resolution if Congress is in session, or the Senate President or the Speaker must sign a certification if Congress is not in session, declaring the existence of vacancies, calling for a special election to be held within 45 to 90 days from the date of the resolution or the certification. And the senator or the representative elected of that special election because of the vacancy only shall serve only for the unexpired term. Section 10. The salaries of senators and members of the House of Representatives shall be determined by law. No increasing in said compensation shall take effect until after the expiration of the full term of all its members and the Senate and the House of Representatives approving such increase. When increase may take effect, no increase in the salaries of senators and representatives shall take effect until after the expiration of the full term of all the members of the Senate and the House of Representatives. So the reason for the delayed effect increased salary, its purpose is to place a legal bar to the legislators, yielding to the natural temptation to increase their salaries. That is in the case of the Philippine Constitution Association versus Matay or Matay. And allowances. A member of the Congress may receive office and necessary travel allowance since allowances take effect immediately. Nor is there a legal limit on the amount that they may be appropriated. The only limit is moral, because according to the Section 20, the books of Congress are audited by the Commission on Audit, which shall publish annually an itemized list of amounts paid and expenses incurred for each member. So, Section 11. A senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress is in session. No member shall be questioned nor be held liable in any other place for any speech or debate in the Congress or any committee thereof. So a member of Congress is privileged from arrest while Congress is in session in all offenses, criminal or civil, not punishable by more than 6 years imprisonment. Privilege is intended to ensure representation of the constituents of the member of Congress by preventing attempts to keep him from attending session. So, parliamentary immunity only includes immunity from arrest and not being filed suit. So, limitation on parliamentary immunity. If the crime has a maximum penalty of not more than 6 years. If the Congress, number 2, if the Congress is in session, whether regular or special. Number 3, prosecution will continue independent of arrest. And number 4, will be subject to arrest immediately when Congress adjourned. While in session, the privilege is available while the Congress is in session, whether regular or special, and whether or not the legislator is actually attending a session. Session, as here used, does not refer to the day-to-day meeting of the legislature, but to the entire period from its initial convening until its final adjournment. Hence, privilege is not available while Congress is in recess. Why not available during recess? Privilege of speech and debate enables the legislator to express views bearing upon public interest without fear of accountability outside the halls of the legislature for his inability to support his statements with the usual evidence required in the court of justice. In other words, he is given more leeway than the ordinary citizen in the ventilation of matters that ought to divulge for public good. So in the case of Osmeña versus Pendaton cited in Pobre versus Defensor Santiago in 2009, to enable and encourage a representative of the public to discharge his public trust with firmness and success, for it is indispensably necessary that he should enjoy the fullest liberty of speech and that he should be protected from resentment of everyone, however powerful, to whom the exercise of the liberty may occasion offense. So, the privilege is a protection only against forums other than the Congress itself, just like in the case of Osmeña versus Pendaton. Speech or debate includes utterances made in the performance of official functions such as speeches delivered, statements made, votes cast, as well as bills introduced and other acts done by the performance of official duties. Section 12. All members of the Senate and the House of Representatives shall, upon assumption of office, make a full disclosure of their financial and business interests. They shall notify the House concerned a potential conflict of interest that may arise from the filing of a proposed legislation of which they are authors. This provision speaks of duty to disclose the following. First is the financial and business interests upon assumption of office. Second is potential conflict of interest that may arise from filing of a proposed legislation of which they are authors. A public officer or employee shall, upon assumption of office, and as often required by law, submit a declaration under the oath of his assets, liabilities, or net worth. Example, me as a barangay kagawad, I should submit or I shall declare my SALN on the office of the Ombudsman. No? Cases wherein declarations shall be disclosed to the public in the manner by law. All members of the Senate and the House of Representatives, upon the assumption of office, make a full disclosure of their financial and business interests. The record and books of account of Congress shall be preserved and be open to the public in accordance with law. Or such books shall be audited with a commission and audit, which shall publish annually an itemized list of amounts and expenses incurred for each member. Section 13. No senator or member of the House of Representatives may hold any other office or employment in the government, or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. During his term, without forfeiting his seat, neither shall he be appointed to any office which may have been created or the emoluments thereof increased during the term for which he was elected. So this section provides to the prohibition of disqualification of a senator or any member of the House of Representatives to hold any other office or employment in the purpose of making the office significant obligation and not a mere sideline. It is violative of the very essence of democracy, and occupying another position deprives his constituency of its representation in the Congress. And the purpose of prohibition of incompatible offices is to prevent from owing loyalty to other branch of government, to the detriment of the independence of the legislature and the doctrine of the separation of powers. So we are halfway of this, one of the longest article in the Philippine Constitution, the 1987 Philippine Constitution. Section 14. No senator or member of the House of Representatives may personally appear as counsel before any court of justice or before the electoral tribunals or quasi-judicial and other administrative bodies. Neither shall be directly or indirectly may be interested financially in any contract with or in any franchise or special privileges granted by the government or any subdivision, agency, or instrumentality thereof, including any government-owned and controlled corporation or its subsidiary. During his term of office, he shall not intervene in any matter before any office of the government for his pecuniary benefit, where he may be called upon to act on the account of his office. So, the purpose is to prevent the legislator, from exerting undue influence, deliberately or not, upon the body where he is appearing. A congressman may not buy a nominal account of shares in a corporation, which is the party to a suit before the SEC, and then appear in an intervention that which the Constitution directly prohibits may be done by in the it does not apply the law firm where a lawyer congressman may be a member. The lawyer legislator may still engage in the practice of his profession except when it comes to trials and hearings before the bodies. Appearance will be not made by him but by some member of his law office. A congressman cannot sign pleadings as a counsel to a client, just like in Villegas case. Section 15. The Congress shall convene once every year on the fourth Monday of July for its regular session, unless a different date is fixed by law, and shall continue to be in session for such number of days as it may determine until 30 days before the opening of its next regular session, exclusive of Saturdays, Sundays, and legal holidays. The President may call a special session in any time. So, we have this regular session where Congress shall convene once every year for its regular session. Congress shall convene on the fourth Monday of July. And also we have this special session. A special session is once called by the President while the legislature is in the recess. We have this also mandatory recess or mandatory recess. A mandatory recess is a prescribed for the 30-day period before the opening of the next regular session, excluding Saturdays and Sundays and legal holidays. This is the minimum period of recess and may be lengthened by the Congress in its discretion. It may, however, be called in a special session at any time by the President. The President's call is not necessary in some instances. When the Congress meets to canvass the presidential elections, to call a special election with both the presidency and the vice presidency are vacated, when it decides to exercise the power of impeachment where the respondent is the President himself. Section 16. Number 1. The Senate shall elect its President and the House of Representatives its Speaker by a majority vote of all its respective members. Each House shall choose such other officer as it may deem necessary. Number 2. A majority of each House shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may compel the attendance of absent members in such manner and under such penalties and as such House may provide. Number 3. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 of all its members, suspend or expel a member. A penalty of suspension when imposed shall not exceed 60 days. Number 4. Each House shall keep a journal of its proceedings and from time to time publish the same, excepting such part as may, in its judgment, affect national security, and the yes and nays on any question shall, at the request of the 1/5 of the members present, be entered in the journal. Each House also shall keep a record of its proceeding. Neither House during the session of the Congress Congress shall, without the consent of other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. So, the election of officers, which is the Senate President and the Speaker of the House. Such officers are deemed by each House to be necessary. They are elected by the majority of all respective members, and as well as the majority of each House shall constitute a quorum. A smaller number may adjourn from a day to day and may compel the attendance of absent members. In computing a quorum, members who are outside the country, thus outside of each House coercive jurisdiction, are not included. Majority refers to the number of members within the jurisdiction of the Congress. In this case, one senator was out of the Philippines, which is not within the jurisdiction of the state, so that the working majority was 43 senators. There is a difference between a majority of all members of the House and the majority of the House, the latter requiring less number than the first. Therefore, an absolute majority, 12 all members of the Senate, at least 23 constitutes a constitutional majority of the Senate for the purpose of the quorum. Section 17. The Senate and House of Representatives shall each have an electoral tribunal, which shall be the sole judge of all contests relating to the election, returns, and qualifications of the respective members. Each electoral tribunal shall be composed of 9 members, 3 of them whom shall be justices of the Supreme Court to be designated by the Chief Justice, and the remaining 6 shall be members of the Senate or the House of Representatives, as the case may be, who shall be chosen on the basis of proportional representation from the political parties and the parties of organizations registered under the party list system represented therein. The senior justice in the electoral tribunal shall be its chairman. The nature of function or the jurisdiction of the electoral tribunal is to be the sole judge of all the contests relating to the election, returns, and qualification of the respective members, and the electoral tribunal has jurisdiction only when there is an election contest. So, election contest is the one where a defeated candidate challenges the qualification and claims for himself on the seat of the proclaimed winner. The electoral tribunal of each house is the sole judge of all the contests relating to elections, returns, and qualifications again. In the absence of election contest, the electoral tribunal has no jurisdiction. The electoral tribunals are independent and constitutional bodies and cannot be regulated by the Congress. Supreme Court has jurisdiction over the Electoral Commission and the subject matter of the present controversy for the purpose of determining the character, scope, and extent of the constitutional grant to the Electoral Commission as the sole judge of all contests relating to election, returns, and qualification of the members on the National Assembly. That is in the case of Angara versus Electoral Commission in 1936. Section 18. There shall be a commission and appointments consisting the President of the Senate as an ex officio chairman, 12 senators, and 12 members of the House of Representatives elected by each House on the basis of proportional representation from the political parties and parties or organizations registered under the party list system represented therein. The chairman of the commission shall not vote except in the case of a tie. The commission shall act on all appointments submitted to it within 30 session days of the Congress from their submission. The commission shall be ruled by a majority vote of all members. Section 19. The electoral tribunals and the commission on appointments shall be constituted within the 30 days after the Senate and the House of Representatives shall have been organized with the election of the President and the Speaker. The commission on appointments shall meet only while the Congress is in session, at the call of its chairman or majority of all members, to discharge such powers and functions as are here conferred upon it. So, the 12 senators and the 12 representatives are elected on the basis of proportional representation from the political parties and party-list organization. The authority of the House of Representatives to change its representation in the Commission of Appointments to reflect at any time the changes that may transpire in the political alignments of its membership. And it is understood that changes in membership must be permanent and do not include the temporary alliances or factional divisions not involving severance of political loyalties or formal disaffiliation, and the permanent shifts of allegiance from one political party to another. That is in the case of the Asa versus Singson of 1989. The commission appointments shall be constituted within 30 days after the Senate and the House of Representatives shall be organized with the election of the President and the Speaker. The commission appointments shall act on all appointments within 30 session days from their submission to Congress. The commission appointments shall rule by a majority vote of all its members. The Commission of Appointments also shall meet only while the Congress is in session. Meetings are held at the call of the chairman of by the majority of all its members. Since the Commission of Appointments is also an independent constitutional body, its rules of procedures are also outside the scope of congressional powers as well as that of the judiciary. So, the Commission appointments shall confirm the appointments by the President with respect to the following positions. Example, head of the executive department, except if it is the Vice President who is appointed to the post, ambassadors or other public ministers or consuls, officers of the AFP from the rank of colonel or naval captain, or other officers whose appointments are vested in him by the Constitution, example, are the Congress members. Congress cannot by law acquire the appointment of a person to an office created by such law shall be subject to confirmation by the Commission of Appointments. Appointments is extended by the President to the above, to the mentioned position a while ago, while the Congress is not in session, shall only be effective until disapproval by the Commission on Appointments or until the next adjournment of the Congress. Section 20. The records and books of accounts of a Congress shall be preserved and be open to the public in accordance with law, and such books shall be audited by the Commission on Audit, which shall publish annually an itemized list of amounts paid to and expenses incurred for each member. Each house shall keep a journal of its proceedings, and from the time to publish the same. So what is a journal? A journal is usually an abbreviated account of daily proceedings. A legislative journal is defined as the official record of what is done and passed in the legislative body. It is also called because the proceedings are entered therein in chronological order as they occurred from day. The purpose of the requirement that a journal be kept is to ensure publicity that to proceedings of the legislature and the correspondent responsibility of the members of the respective constituents, and to provide proof of what actually transpired in the legislature, that is in the case of Field versus Clark. So, matters which under the Constitution are to be entered in the journal. the yes and nays on the third and final reading of a bill, veto message of the President, the yes and nays on the repassing of a bill that vetoed by the President, the yes and nays on any question on the request of the 1/5 of the members present. So, what is a record? The record contains a word-for-word transcript of the deliberation of the Congress. Section 21. The Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. The rights of persons appearing or unaffected by such inquiries shall be respected. So, who has the power? The Senate or the House of Representatives or any of its respective committees may conduct inquiries in the aid of legislation. In the case of Arnold versus Nazareno, the power of inquiry is an essential and appropriate auxiliary to legislative action. It has been remarked that the power of legislative investigation may be implied from the express power of legislation and does not itself have to be expressly granted. So its limitation is it must be in the aid of legislation only and it must be in accordance with the duly published rules of procedures. Section 22. The heads of departments may, upon their own initiative with the consent of the President, or upon the request of either House as the rules of each House shall provide, appear before and be hereby heard by such House on any matter pertaining to their departments. Written questions shall be submitted to the President of the Senate or in the Speaker of the House of Representatives at least 3 days before their scheduled appearance. Interpellations shall not be limited to written questions, but may cover matters related thereto. When the security of the state or the public interest so requires and the President so states in writing, the appearance shall be conducted in executive session. The provision or this section formalizes the oversight function of Congress. Section 22 establishes the rule for the exercise of what is called the oversight function of Congress. Such function is intended to enable Congress to determine how laws it has passed are being implemented. Oversight function, broadly defined, congressional oversight embraces all activities undertaken by the Congress to enhance its understanding of and influence over the implementation of legislation it has enacted. This act done by Congress in the exercise of its oversight powers may be divided into 3 categories, to wit, scrutiny, investigation, and supervision. The head of the departments may, upon their own initiative, with the consent of the President, appear before and be heard by either House or any matter pertaining to their departments. So why is the permission of the President needed? In the deference to separation of powers and because department heads are alter egos of the President, they may not appear without the permission of the President. Section 23. The Congress, by a vote of 2/3 of both houses in joint session assembled, voting separately, shall have the sole power to declare the existence of war. In times of war, other national emergency, the Congress may, by law, authorize the President for a limited period and subject to such restrictions it may prescribe to exercise power necessary and proper to carry out a declared national policy. Unless sooner withdrawn by a resolution of the Congress, such power shall cease upon the next adjournment thereof. So, the power to declare existence of a state war by the Congress is by a vote of 2/3 of both houses in a joint session assembled. Voting separately shall have a sole power to declare the existence of a state war. So, May a country engage in a war in the absence of declaration of a war? Yes. The actual power to make war is lodged in the executive, and the executive, when necessary, may make war even in the absence of declaration of a war. Section 24. All appropriation, revenue, or tariff bills, bills authorizing increase of the public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. So, all appropriation, the revenue or tariff bills, bills authorizing increase of the public debt, bills of local application, originate exclusively only in the House of Representatives. The exclusivity of the prerogative of the House of Representatives means simply that the House alone can initiate the passage of revenue bill, such that if the House does not initiate, no revenue law will be passed in the case of Tolentino versus Secretary of Finance. 25. The Congress may not increase the appropriation recommended by the President for the operation of the government as specified in the budget. The form, content, and manner of preparation of the budget shall be prescribed by law. Number 2. No provision or enactment shall be embraced in the General Appropriation Bill unless it relates specifically to some particular appropriation therein. Any such provision or enactment shall be limited in its operations to the appropriation to which it relates. Number 3, the procedure in approving appropriation for the Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. Number 4, a special appropriation bill shall specify the purpose for which it is intended and shall be supported by funds actual available as certified by National Treasurer or to be raised by corresponding revenue proposed therein. Number 5, no law shall be passed authorizing any transfer operation. However, the President or the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the Head of Constitutional Commission may by law be authorized to augment any item in the General Appropriation Law for their respective offices on the saving and other items of their respective appropriations. Number 6, discretionary funds appropriated for particular officials shall be dispersed only for public purpose to be supported any appropriate vouchers and subject to such guidelines as may be prescribed by law. And number 7, by the end of the fiscal year, the Congress shall have failed to pass the General Appropriation Bill for ensuing fiscal year. The General Appropriation Law for the preceding fiscal year shall be deemed reenacted and shall remain the force of effect until the General Appropriation Bill is passed by the Congress. Honestly, I don't also understand this section, the Section 25 of the 1987, of the Article 6 of the 1987 Philippine Constitution, and I am begging for your pardon because I will skip to Section 26. Section 26. Every bill passed by the Congress shall embrace only one subject, which shall be expressed in the title thereof. No bill passed by the either house shall become law unless it has passed 3 readings on separate days, and printed copies thereof in its final form have been distributed to its members 3 days before its passage, except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency. Upon the last reading of a bill, no amendment thereto shall be allowed, and vote thereon shall be taken immediately thereafter, and the yes and nays entered in the journal. So every bill passed by the Congress shall embrace only one subject, and the subject shall be expressed in the title of the bill, and this rule is mandatory. Again, the subject shall be expressed in the title of the bill and is mandatory. The requirement is satisfied when all parts of the law relate to subject expressed in the title, and second, it is necessary that the title be a complete index of a content in the case of Philippine Constitution Association versus Menes. So the purpose of this rule is to prevent hodgepodge or log ruling legislation. Second is to prevent surprise or fraud upon the legislature. And third is, in the case of Central Caucus versus Ramirez, to fairly appraise the people. So this is the procedure of of the bill. A bill is, number one is, a bill is introduced by any member of the House of Representatives or Senate, except some measures that must originate only in the former chamber. The first reading involves only a reading of the number and the title of the measure and its referral by the Senate President or the Speaker to the proper committee for study. Number three, the bill may be killed in the committee or it may be recommended for approval with or without amendments, sometimes after public hearings at first held thereon. If there are other bills at the same nature or purpose, they may all be consolidated into one bill under common authorship or as a committee bill. Once reported out, the bill shall be declared or the bill shall be calendared for second reading. It is this stage that the bill is read in its entirety, scrutinized, debated upon, and amended when desired. And the second reading is the most important stage in the passage of bill. Again, second reading is the most important. And the bill is, if the bill is approved, the second reading is printed in its final form, and the copies thereof are distributed at least 3 days before the third reading. And on the third reading, the members merely register their votes and explain them if they are allowed by the rules. No further debate is allowed. And once the bill passes through third reading, it is sent to another chamber, where it will also undergo the 3 readings. If it also approved by the second house, it will be submitted to the President for his consideration. The bill is enrolled when printed as final, approved by the Congress, thereafter authenticated with the signature of the Senate President, the Speaker, and the Secretaries of the respective chamber, and approved by the President. Section 27. Every bill passed by the Congress shall, before it become law, be presented to the President. If he approves the same, he shall sign it, otherwise he shall veto it, and return the same disobjection to the House where it originated, which shall enter the objection at large in its journal and proceed to reconsider it. If after such reconsideration 2/3 of the members of such House shall agree to pass the bill, it shall be sent together with objection to the other House, by which it shall be likewise considered and approved by the 2/3 of all the members of the House. It shall become a law. In such a case, the votes of each House shall be determined by a yes or nays, and the names of the members voting for against shall be entered in its journal. The President shall communicate his veto of any bill to the House where it originated within the 30 days after the date of receipt thereof. Otherwise, it shall become law as if he had signed it. Number 2, the President shall have the power to veto any particular item or items in appropriation, revenue, or tariff bill, but the veto shall not affect item or items to which does not object. So there are 3 methods by which a bill may become law. First is when the President signs it. Second is when the President vetoes it, but the veto is override by the 2/3 of all the members of each House. And the third one is when the President does not act upon the measure within 30 days after it shall have to be presented to him. So the presidential approval. Passed bill is presented to the President. The President signs the bill, he approves the same, and the bill becomes law. For presidential veto, passed bill is presented to the President. President vetoes the bill. If he does not approve it, he returns the passed bill with his objection to the House where it originated, with his veto message. And general rule, if the President is approved the bill approved by the Congress, he should veto the entire bill. He is not allowed to veto separate items of a bill. And exceptions, President may veto an item in case of appropriation, revenue and tax bill, and President may veto inappropriate provisions or riders. So legislative reconsideration of the bill. The House where the bill originated enters the objection of the President at large in its journal. Said House reconsiders the bill. Two-thirds of all the members members of the House agree to pass the bill. The bill together with the objection is sent to another House by which it is also reconsidered. The other House approves the bill by two-thirds of all the members of the House, and the bill becomes law. In all such cases, the vetoes of each House shall be determined by yes or nays, and the names of the voters members voting for or against shall be entered in its journal. When it comes to presidential inaction, if the passed bill is presented to the President, and the President does not approve nor communicate his veto to the House, where it will be originated in 30 days, the bill becomes law. Section 28. The rule of taxation shall be uniform and equitable. The Congress shall evolve a progressive system of taxation. Number 2, the Congress may by law authorize the President or fix within specified limits and subject to such limitations and restrictions as it may impose tariff rates, import and export quotas, tonnage and mortgage dues, and other duties, or imposed within the framework of the National Development Program of the government. Third, charitable institutions, churches and parsonages or convents pertinent thereto, mosques, non-profit cemeteries, and all lands, building, and improvements actually directly and exclusively used for religious, charitable, educational purposes shall be exempt from taxation. No law is granting any tax exemption shall be passed without the concurrence of a majority of all the members of the Congress. When it says taxation, it refers to the inherent power of the state to demand, enforce, and contribution for public purposes. And taxation is pervasive, that it reaches even the citizen abroad and his income earned from the source outside the state. So for general limit is for a public purpose, due process, and equal protection clauses, in the case of Season versus Ancheta. When it comes to specific limit, it should be uniform and equitable, and for the exercise of power is to primarily vested in the national legislature. So the purpose of taxation is to raise revenue. It is the instrument of national economic and social policy. It is a tool for regulation. And it is the power to keep alive. Taxes are enforced social contribution from persons and property levied by the law-making body of the state by virtue of its sovereignty for the support of the government and all public needs. As was Justice Holm said, taxes are what we pay for civilized society. Section 29. No money shall be paid out of the treasury except in the pursuance and appropriation made by law. Number 2, no public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support or any sect, church, domination, sectarian institution, or system or religion, or any priest, teacher, minister, or other religious teacher or dignity as such, except when such priest, teacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government orphanage or leprosarium. All money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. If the purpose for which a special fund was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. So behind the provision stand the principle that the people's treasury may be sent only with their consent, that the consent is to be expressed either in the Constitution itself or in the valid acts of the legislature or directly representative of the people. Section 30. No law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in this Constitution without its advice and concurrence. So, the limitation on the power of Congress. And as well as the Supreme Court's advices and the concurrence needed, the Congress may increase the appellate jurisdiction of the Supreme Court but only with the advice and concurrence. The reason why is to prevent further addition to present tremendous caseload of the Supreme Court, which includes the backlog of the past decades. And Section 31, no law granting a title or royalty or nobility shall be enacted. It is to preserve the republican and democratic nature of our society by prohibiting the creation of privileged classes with special prerequisites not available to the rest of the citizenry. And Section 32, the last section of this article, the Congress shall as early as possible provide for any system of initiative and referendum, and the exception therefore, whereby the people can directly propose and enact laws or approve or reject any act or law or or part thereof passed by the Congress or local legislative body after the registration of a petition therefore signed by the least 10% of the total number of registered voters, of which every legislative district must be presented to at least 3% of the registered voters thereof. So, the Congress must conduct a system of initiative and referendum so that people can directly propose and enact, approve, and reject any law passed by the Congress that will be signed by 10% of the total registered voters and 3% of the total registered voters of the legislative district. And that's it. The 32 sections of Article 6 of the 1987 Philippine Constitution, which is the legislative department. And I hope I explained the legislative department. I know that I am not that expert with this. This is not my expertise, but I know I've tried my best. So thank you and God bless.